You walk off a 14-hour flight. You've done everything right. Valid visa, valid passport, return ticket, hotel reservations, and then a CBP officer pulls you aside and says, "Sir, we're going to need to see your bank statements, all of them, going back 5 years. Not 1 year, not 2, 5 years." That happened, and it is happening more frequently than anyone is officially talking about right now. If you are a visa holder, a green card applicant, a non-immigrant traveler, or someone with any kind of pending immigration case, what I'm about to break down in the next 12 minutes could genuinely affect your ability to enter, stay, or remain in this country. Stay with me. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. No rumors, no panic, no speculation, just the policy, the law, and what it means for real people in real situations. Before we go further, I am not your attorney. This content is strictly for educational and informational purposes. Whatever your situation is, always consult with a licensed immigration attorney about your specific case. What I give you here is context and clarity. What your attorney gives you is legal advice tailored to you. Those are two very different things. Now, let's talk about what is actually happening at the border right now, and why your bank account has become one of the most scrutinized documents in immigration enforcement. To understand why a CBP officer is now asking for 5 years of financial records, you have to understand 3 things that converged almost simultaneously in late 2025 and early 2026. The first is a proposed executive action. The second is a federal enforcement operation called Operation Twin Shield. And the third is a CBP data collection expansion that quietly went through the Federal Register with very little public attention. Let's take each one. In February 2026, reporting from El País and several legal policy outlets confirmed that the White House was actively considering an executive order that would require financial institutions, banks, credit unions, fintech platforms to verify the citizenship and immigration status of their customers. The framing behind this policy is rooted in 2 enforcement priorities that this administration has elevated above almost everything else: public charge determination and unauthorized employment. Now, public charge is not a new concept. It has existed in immigration law for over a century. Under the Immigration and Nationality Act, an applicant for admission or adjustment of status can be denied if the government determines they are likely to become primarily dependent on public benefits. That has always been part of immigration law. But here's where this becomes critical. What is new, and what makes this moment different from anything we've seen in recent memory, is the method. Previously, public charge determinations were made during the visa application process, during adjustment of status interviews, during consular processing. They were conducted in a structured legal environment where applicants had notice, had counsel, and had the right to respond. What is now being reported and what is being observed at ports of entry is that CBP officers in secondary inspection are using financial record review as a real-time enforcement tool, not as part of a formal immigration court proceeding, not with advance notice, at the border, in the moment, with your phone in their hand. Let's talk about Operation Twin Shield. This is a joint initiative between USCIS and CBP that originated in Minneapolis and has since expanded nationwide. The official DHS reporting on this operation is striking. In 44% of the cases reviewed, investigators found what they characterized as fraud, specifically instances where an individual's bank account activity did not match their reported income, their stated occupation, or their claimed immigration status. Think about what that means. Nearly half of the targeted cases showed a discrepancy between what someone said they did for work and what their money was actually doing. That is the trigger. That is what law enforcement is looking for. Unauthorized employment is the specific concern here. Under United States immigration law, most non-immigrant visa categories, tourist visas, certain student statuses, visa waiver program entries, do not authorize work. If you are on a B1, B2 visitor visa and your bank account shows regular, consistent deposits that look like employment income, that is a red flag under Operation Twin Shield's criteria. And here's what most people are misunderstanding right now. They think this only applies to people who are actually working illegally, but that's not how a secondary inspection works. A CBP officer doesn't need proof. They need reasonable suspicion. And reasonable suspicion in a secondary inspection context is a very, very low threshold. If your financial records raise a question, even a question you can fully explain with documentation, you may still face extended detention, further questioning, or in the most serious cases, a finding of inadmissibility. Now let's talk about the third piece of this. And this is the one that is perhaps most underreported: In late 2025, CBP filed a notice in the Federal Register indicating an expansion of personal data collection at the border. This notice, which received limited mainstream coverage, outlined that CBP would begin collecting what they termed financial metadata, in addition to previously authorized social media and travel data. Al Jazeera's reporting in early 2026 highlighted this notice specifically, noting that travelers could be asked to provide up to 5 years of personal data, including social media history and financial account information, as part of enhanced vetting procedures. The legal basis for this is what's known as the border search exception to the Fourth Amendment. Under long-standing federal case law, CBP has broad authority to search individuals and their belongings at the border, including electronic devices, without a warrant and without probable cause. Courts have consistently upheld this authority. In 2026, this authority is being applied to financial applications on phones, bank apps, payment platforms, transaction histories. Verdun Law's 2026 update on secondary inspection rights makes this explicit. If you are in secondary inspection and an officer asks to review your phone, they have the legal authority to access your banking applications and scroll through your transaction history. Declining can itself be used as a basis for further scrutiny or denial of entry. This is not theoretical. This is the current operating environment at U.S. ports of entry. Let me give you a scenario that illustrates exactly how this plays out in practice and why it matters for people who are doing nothing wrong. Consider a woman, we'll call her Amara, who came to the United States on an F1 student visa 3 years ago. She graduated, she's now on OPT, and she has an approved H-1B petition waiting for her to cross back from a brief trip home to visit her parents. She's followed every rule. Her status is valid. Her employment authorization is active. But Amara has been sending money home to her family every month, small amounts, through a mobile app, and she has a secondary income from an online tutoring platform that she set up before she started her OPT. She stopped using it once her OPT began because she wasn't certain if it was authorized, but the account is still open. There are historical deposits. Amara lands at the airport. She's sent to secondary. An officer reviews her phone. They see the tutoring platform deposits from 18 months ago. They see the international remittances. They ask her to explain the income history. She explains, but she doesn't have documentation with her. She has no letter from her DSO. She has no records proving the tutoring income predates her current status authorization. She is detained for 6 hours. She misses her connection. She is ultimately admitted, but placed under deferred inspection, meaning she has to appear before a CBP officer at a local port of entry within a set number of days to provide the documentation they requested. She did nothing wrong, but the system put her through something traumatic, time-consuming, and genuinely frightening, all because her bank history raised a flag that she had no way to anticipate would be examined. That is why this matters. Not just for people in irregular situations, for people in perfectly legal situations who simply haven't prepared. There's one detail most people are missing when they think about this issue. The CBP's expanded data collection authority doesn't just apply to your current status, it reaches back. 5 years of financial history means 2021 onward. That period includes the pandemic years, a time when many people in valid immigration status received government stimulus payments, unemployment assistance, or emergency relief. Some of those benefits were lawfully available to non-immigrants, some were not, and many people genuinely didn't know the difference at the time. If you received any federal, state, or local public benefits during that window, even inadvertently, even briefly, that history may now be visible and relevant in a secondary inspection context. This is not a reason to panic. This is a reason to be prepared. Here is what I want you to do after you finish watching this video. Step 1. Pull your own financial records for the past 5 years. All of them, every account, every platform. Review them the way a CBP officer would, not with the context you have in your own head, but with fresh eyes. Ask yourself, does this look like regular international travel and personal spending, or does it look like employment income? Step 2. Document everything that might look unusual. Remittances to family abroad, get records of those. Freelance payments, have your contracts and tax filings ready. Any public benefits you received, verify whether those benefits were lawfully available to someone in your status at the time, and consult an attorney if you have any uncertainty. Step 3. If you are traveling internationally in the next 6 months, carry a financial documentation packet. This doesn't have to be elaborate. It should include your most recent bank statement, evidence of your income source, and, if you're on a work-authorized status, a copy of your employment authorization or approval notice. Step 4. Understand your rights in secondary inspection. You have the right to remain silent beyond providing your identity and travel documents. You have the right to request the presence of a consular officer if you are a foreign national. You do not have the right to refuse a device search at the border, but you can note your objection for the record and contact an attorney as soon as you are released. Step 5. Consult a licensed immigration attorney before your next international trip if you have any complexity in your financial or immigration history. A 1-hour consultation is infinitely less expensive than a deferred inspection, a finding of inadmissibility, or a deportation order. Now let me give you the broader policy context, because what we are seeing right now is not just enforcement, it is a system in transition. The proposed executive order on bank citizenship verification has not yet been signed into law. It is at the consideration stage, which means it could be implemented quickly through executive action, or it could face legal challenges that slow or block its rollout. The administrative procedure required for a formal regulation would typically require a notice and comment period, but executive orders can sometimes bypass that process, depending on how they are structured. What is already in place, and this is important, are CBP's existing border search authorities. Those don't require new legislation. They don't require a new executive order. They are already the law. What Operation Twin Shield and the Federal Register Data Collection Notice have done is create a policy framework that tells CBP officers, use these authorities systematically, not occasionally, routinely. That shift, from occasional use of a legal power to routine, systematic use, is the actual news story. And it is happening now, not in some future policy landscape. It is happening today at JFK, at LAX, at O'Hare, at every international port of entry. This could affect you even if you're not in an irregular situation. It could affect a family member, it could affect a colleague, it could affect anyone whose financial history is more complex than a single direct deposit paycheck. I want to be honest with you about what is at stake here, because immigration is not just a legal category, it is someone's life. Your immigration status connects to where your children go to school. It connects to whether your spouse can work. It connects to whether you can visit an aging parent abroad and come home again. It connects to a decade of planning, sacrifice, and quiet determination that most people outside this community will never fully understand. The people sitting in secondary inspection rooms right now are not abstractions. They are engineers and nurses and students and business owners and parents. They deserve accurate information. They deserve to know what authorities exist, how those authorities are being used, and what they can do to protect themselves within the law. That is what this channel exists to do. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Drop your visa category in the comments below. I read everyone, and it helps me understand what topics matter most to this community. If you know someone traveling internationally in the next few months, or someone with a pending immigration case, please share this video with them. It could genuinely matter for their situation. And if this kind of fact-based, policy-grounded analysis is valuable to you, hit the like button. It's the simplest way to tell the algorithm that this content deserves to reach more people who need it. I'll see you in the next one.